the University of Commemoration of the Roe versus Wade anniversary. I'm Vicki Reeder. Our branch has been commemorating this day for many years, since I first observed a group prayer vigil opposing Roe, doing a protest walk on the main street of downtown Los Altos. That year, we took note, and the next year, we organized a counter protest, which we did every year thereafter. I'm very pleased to welcome Professor and podcaster Leah Litman to this webinar today. She is a professor of law at the University of Michigan Law School and is co-host of Strict Scrutiny, a podcast about the Supreme Court, alongside Melissa Murray and Kate A. Shaw. I encourage you to watch Strict Scrutiny on YouTube so you can enjoy seeing the many feminist slogans that Leah wears on her various shirts when she does her show. Leah received a BA in chemistry from Harvard and a JD degree, summa cum laude, from the University of Michigan Law School. She was a law clerk to Judge Jeffrey Sutton on the Sixth Circuit from 2010 to 2011, and then for Justice Anthony Kennedy from 2011 to 2012. She was a fellow at Harvard Law School, then an assistant professor of law at UC Irvine School of Law, and in 2019, she joined the University of Michigan Law School. She was also a visiting assistant professor of the Supreme Court Litigation Clinic at Stanford Law School. In 2023, she received the Ruth Bader Ginsburg Scholar Award from the American Constitution Society. Her book, which is a New York Times bestseller, and is called Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. And I read it recently. I say it's an eye-opening account of just how long the long game has been in place to derail and overturn reproductive choice. Leah, thank you very much for joining us today. The floor is yours.
Thank you so much for having me. So I tried to wear one of my t-shirts today that's relevant to the talk. It says 1973, the year Roe versus Wade was decided, to mark the occasion. So I wanted to touch on a few different matters in my remarks, and then I'm happy to take questions. There are so many issues we could talk about. I wanted to ensure we were focusing on what was most of interest to you all. And I will also answer the questions that were submitted to Vicki in advance of the talk, as part of my initial remarks, before we kind of open it up to questions from the group. So what I wanted to talk about today was the aftermath of Roe and what that has meant for constitutional protections for reproductive freedom, for regulation at the federal level of matters of reproductive rights and justice, for developments in the states on, again, issues of reproductive rights and justice more broadly, as well as our legal culture and society and what the overruling of Roe kind of happened in tandem with. So I will start with just the kind of overruling of Roe and the landscape that has created, across different states as far as the law of reproductive freedom. Immediately after the Supreme Court overruled Roe, trigger bans in several states went into effect. Trigger bans are laws that were designed to ban abortion in the event the Supreme Court overruled Roe versus Wade. The existence of these laws, reflects what Vicki alluded to, in her remarks introducing me, which is that the campaign to overrule Roe versus Wade was a long one. That was decades in the making, and that people who were pushing for the overruling of Roe knew it was coming and thought was coming, whereas people who were committed to reproductive freedom and reproductive justice, many of them were taken by surprise, although they shouldn't have been. So the overruling of Roe has meant immediately, there was a patchwork of legal protections for reproductive rights and justice throughout the United States. In red-leaning Republican-controlled states, there were many states that opted for complete and total abortion bans. And the fallout from those bans, we have really read kind of a slow drip of information about. The Georgia Maternal Mortality Commission, as well as the Texas Maternal Mortality Commissions, concluded that women in those states had died, because they were denied or delayed in receiving miscarriage management care due to abortion bans. After those reports came out, however, the states disbanded their maternal mortality commissions, I think, so as to prevent additional information and additional stories about women dying because of these abortion bans. So instead of, these state commissions really trying to keep track of the public health situation in the states, journalists have had to step into the breach. ProPublica has been doing, I think, the most important work documenting and trying to uncover stories of women who were denied medical care and had their lives, health, safety, fertility threatened or taken from them as a result. I think one of the most shocking things for me in the aftermath of Roe is the reality that even these reported deaths, again, in cases where state maternal mortality commissions concluded that the deaths were attributable to the abortion bans, even that did not really lead to a widespread national backlash and movement to restore, legal protections for women's medical care and their bodily autonomy. Because, in the period of the lead up to the overruling of Roe, other countries moved in the opposite direction as we did as far as the liberalization of abortion regulations. In Ireland, the story of the woman who died from sepsis, after she was denied abortion care at an Irish hospital is what led that country to liberalize its abortion restrictions. We have not seen the same reaction from places in the United States or the United States as a whole. And I think that has been one of the more dispiriting aspects of the last 4 years for me. Um, on the other side, we have seen blue, Democratic leaning states try to codify additional protections for reproductive freedom in their laws. These include so-called shield laws that attempt to offer protections for doctors or medical practitioners in their states who offer medical advice or medical treatment to people in other states, where abortion might be illegal. Those laws are going to be tested as we have seen states like Louisiana and Texas attempt to reach out and impose civil penalties, or other kinds of legal liability on doctors outside of their states, who are assisting, citizens of their states. Um, you know, the third category is in, purple states, states that have gone, Republican or Democrat over the last few cycles. I think we have seen a pretty universal trend of when abortion and reproductive rights are on the ballot, people support, access to abortion and reproductive rights. Here in Michigan, we are one of the states that added constitutional protections for reproductive freedom, after the Supreme Court overruled Roe versus Wade. Abortion protections have a near universal winning record, in states that were allowed to vote on abortion protections, after Roe versus Wade. That being said, we have seen states take numerous steps to try to undermine, the protections that citizens want to try to place in their state laws for reproductive freedom. In Missouri, for example, we've really seen, I think, an all-out campaign by, Missouri Secretary of State and other state officials. We also had this in Michigan, where, groups that were opposed to abortion protections tried to prevent ballot initiatives that would have safeguarded reproductive freedom from actually getting on the ballot, and allowing people to vote on that. So that's kind of a state by state roundup of what has been happening, in the aftermath of Roe. There are now a patchwork of laws. They really span the entire spectrum. And the reality is your access to your medical care, access to rights depends on where you live and where you happen to be, at the moment where you need medical care. I wanted to touch on a few developments at the federal level, some of which have already happened, some of which are, I think, very much in the works. So what has already happened? At the end of last year, over the holiday season, we received the formal announcement that the Department of Veteran Affairs was banning, Veterans Affairs facilities from offering abortion care, even in cases of rape or incest. That ban affects, not only veterans, the people who put their lives on the line to defend this country. We are denying them medical care. It also affects people who depend on veterans, and have health insurance and health care protections, because of their relationship to a veteran. So this is really a broadside, withdrawal of access to medical care for a population that you would think, the federal government owes a lot to. The administration also passed, as part of the law called either Big Beautiful Bill, Big Ugly Bill, you name it, a measure that defunds Planned Parenthood, that does not allow people to obtain reimbursement under the Medicaid program for any care that is received at Planned Parenthood. This is devastating, both for Planned Parenthood as well as for access to health care. Planned Parenthood is sometimes the only provider of, reproductive health care services, gynecological care, in many places, especially rural places, especially places that serve low-income populations throughout the United States. And if you cannot receive care at the only reproductive health care provider, if you depend on Medicaid for your health insurance, then you effectively have no access to reproductive health care. Um, it's also been, I think, a statistic reported that almost half of Planned Parenthood patients, are low income and might rely on Medicaid for their insurance. So withdrawing, that source of, Planned Parenthood's customer base, the population that it serves, is also going to be devastating, for Planned Parenthood's ability to continue to function in the way it was, before the administration stripped its access to the Medicaid program. Um, so those are the developments that have already happened at the federal level. Still in the works, or possibly in the works, are two even more draconian measures that I think the administration is probably holding off on until after the 2026 midterms, because they know how deeply unpopular they will be. One is the possibility that the Department of Health and Human Services, or Food and Drug Administration, will adopt new regulations that dramatically restrict access to mifepristone, one of the two drugs in the current medication abortion protocol. Medication abortion is the most common method of abortion in the United States. It is also essential right now, given the patchwork of laws regarding abortion restriction. It is significantly easier for people who live in states with abortion restrictions to be able to get an abortion via medication abortion than through other measures. And in part for that reason, states that are controlled by Republicans as well as anti-choice organizations have been pushing mightily to restrict access to mifepristone. So what do we know is going on here? Recently, the Senate Health Committee held a hearing on the dangers of mifepristone. We also know that the FDA, has received inquiries and invitations to look into the safety of mifepristone. And all of the reporting suggests this is kind of in the works, but again, they are delaying it, and I think they are slow walking it to make a decision until after the midterms, because a nationwide ban or nationwide, broad restrictions on access to medication abortion would be deeply unpopular. Even more unpopular would be reviving what is known as the Comstock Act, which is an 1873 anti-vice measure that prohibits the distribution of licentious material, including material that can be used in abortions. When Roe versus Wade was the law of the land, the Comstock Act, effectively a federal prohibition on the transportation of items that could be used to facilitate abortions, couldn't be enforced. In the aftermath of Dobbs, the decision overruling Roe, people are saying, well, now the Comstock Act can be used to prosecute people who distribute medication abortion, people who purchase products that would be used in procedural abortions. And there was reporting again in the lead up to the 2024 presidential election that anti-choice groups were pushing the president to commit to enforcing the Comstock Act. Um, his administration has not yet done so, but they have filled, key posts with people who have written in support of enforcing the Comstock Act, which, again, if they revived, would effectively mean there would be a nationwide abortion ban in effect without Congress actually having to pass an abortion ban. And because they know nationwide abortion ban is deeply unpopular, I think this too is something that is likely to wait to happen, if it is to happen, until after the 2026 midterms. So those are some developments that have happened and some developments that might be in the works at the federal level, with respect to protections on reproductive freedom. Um, then we have, measures in the states. And here, I think we are still watching to see what states are going to do beyond their near total abortion bans. And I think we are watching really three developments potentially play out. One is the possibility of states pursuing what is called, the theory of fetal personhood. For those of you who, have not heard of it, fetal personhood is the theory that fetuses are people or persons with rights under the Constitution. If fetuses are people or persons with rights under the Constitution, the theory goes, then they cannot be deprived of life without due process of law. Under that theory, fetal personhood, it would mean that abortion would have to be prohibited nationwide. That is a way of effectively getting the federal courts to constitutionalize a nationwide ban on abortion. Um, we saw, some judges making signals in this direction, in particular, two judges on the courts of appeal who were appointed by Donald Trump in his first term and are listed as possible appointees to the Supreme Court in his second term. They have cited articles that support fetal personhood. So there is a real possibility that we will see states push for and potentially successfully, move the needle further toward a theory of fetal personhood. Another possible development is restrictions on other forms of reproductive health care. Um, it is possible that states will, sprawl out to ban not just abortion, but various forms of contraception, perhaps by classifying it as forms of abortion or abortifacients. We have seen some groups that are opposed to abortion, classify forms of contraception like Plan B or the morning after pill and claim that they are really abortifacients. It is possible that some states will attempt to restrict them, also by purporting to label them as abortifacients and saying that, because they can be treated as abortion, they can be regulated as abortion, which again is no longer entitled to constitutional protection. Um, Here, I'd also be remiss to note that the restrictions on the rights of, transgender individuals are deeply bound up with the restrictions on the rights to reproductive freedom. Because when the court overruled Roe versus Wade in Dobbs, it cast doubt on the idea that the Constitution protects any rights that aren't specifically and explicitly listed in the Constitution and that weren't protected when the Constitution was ratified in the 1700s or the 14th Amendment was ratified in the mid 1800s. And the reality is that many groups, including women, including the LGBT community, were not regarded as full and equal citizens in the 1700s and 1800s. They weren't regarded as people who were entitled to have rights over their own bodies or rights over their own futures. And if that is how courts are going to be defining, who has rights and who has what rights, then the fates of reproductive freedom are linked with, the fates of protections for the LGBT community, and others. The third development I wanted to note, at the state level is the further, criminalization of pregnancy. States are continuing to prosecute individuals who lose their pregnancies, alleging that they did so through behavior that was wrong or criminal, whether that is drug use, whether that is inducing a miscarriage, whether that is negligence, in maintaining the pregnancy. This was something that was happening, before the court overruled Roe, and it is something that has continued to happen after Roe. But we are seeing, again, like the states increasing, monitoring, of individuals and states increasing willingness to assert control and the power to regulate, what women do with their bodies, when they are pregnant. Okay, so those are the kind of legal developments, at the state and federal levels. The last bucket I wanted to touch on, before I turn to the questions that I received from Vicky in advance of this presentation, is something more general, and it is just about, our legal culture, but I think more broadly society. And I just don't think it is an accident that at the same time, we are seeing the rollback of, women's rights over their bodies and rights of access to medical care. We are also seeing, rising levels and rising comfort with fairly open misogyny. After the shooting of Renee Nicole Good, we have seen, the vilification of white women, with some right-wing commentators and conservative commentators suggesting, there's no worse group than white women. We have seen the vilification of wine moms, and really criticizing them as a group, and suggesting that, they are now, according to Stephen Miller and other peoples in the administration, some kind of mob that needs to be controlled. Um, we are also seeing this in the right-wing social media content, that is promoting this trad wife or traditional wife life. We are seeing this in comments from, Vice President J.D. Vance, who referred to, the childless cat ladies as like sociopaths. I think all of these, developments speak to a culture that is increasingly comfortable with treating women as second-class citizens and viewing women as not entitled to the same rights as men. Um, and this is, I think in some ways confirming suspicions that many of us have had over the last few years, the suspicion that why does this person or this colleague always turn to my male colleague, when he asks substantive questions? Why are they asking me to manage more housekeeping or administrative matters? We all knew that society had never fully embraced the idea of sex equality and the idea that women could do everything that men could. I don't know that I realized the depths of deep-seated misogyny and disdain for the idea that women are people who are entitled to participate in all aspects of civic life. I don't know that I anticipated the extent to which people would feel so comfortable openly spouting these ideas. But I think that those, developments in society and culture are related to the rollback of protections for reproductive freedom and sex equality. Um, Okay, so turning to a few questions that I received in advance, and then again, I'm truly happy to answer any questions you all might have um, uh, about, anything kind of touching on this topic. So one question, will we ever be able to get back our reproductive rights? The answer to that has to be yes. Our future isn't preordained. Politics isn't preordained. What is happening now was not written in stone, 10, 15, 20 years ago. It happened because, a certain number of people in certain places opted to vote the way they did. And I have to believe that things can be changed, if we convince a certain number of people in a certain number of places, to vote another way and to vote based on, the idea that women should be able to receive medical care that they need, and that they determine, is appropriate, together with their family and providers. So, you know, I'm not in the business of politics, but will we ever be able to get back our reproductive rights? Again, I have to believe that the answer is yes. Um, related to this, what can we do to ensure, reproductive rights for all women? A few things. One is we have seen the success of ballot measures at the state and local level. So I think organizing in order to get, ballot measures protecting reproductive rights and justice, onto the ballot is an important mechanism. I think making this an issue in state and local elections is also important. Choosing to elect an attorney general who is committed not to criminalizing pregnancy, who is committed not to policing, women's decisions over their own bodies. There are so many state and local positions that have authority and that have powers that relate to access to health care or access to reproductive rights and justice. So staying informed and participating in those elections and organizing about those elections is very important. At the federal level, I think we are seeing primaries, happening now. I think it is very important to keep an eye out for selecting officials who are willing to actually exercise their power to protect reproductive freedom. What do I mean by this? Well, Democrats had control, of the Senate and the House and the White House for a few years. They did not codify protections for Roe. Why not? Well, one big reason is because not enough senators were willing to abolish the filibuster and actually do that in order to pass legal protections for reproductive freedom. I think we need to be on the look for political officials who are actually willing to use their power to protect women's rights and to make our society, more democratic and equal. So I think looking for people who have some fight in them and people who are willing to stand on business and stand on principle is important. Um, Another question I think that is related to this was, what about the Equal Rights Amendment? Would passing the Equal Rights Amendment, guarantee reproductive rights for women? Equal Rights Amendment is, the constitutional amendment that would prohibit measures discriminating on the basis of sex. I think passing the Equal Rights Amendment and a movement, that is organized around the ratification of the Equal Rights Amendment would be great. I do not think that its mere passage would secure access to reproductive rights for a simple reason. The Supreme Court. When the Supreme Court overruled Roe versus Wade in Dobbs, they addressed the argument that the abortion restriction was unconstitutional because it discriminated on the basis of sex. The Supreme Court said abortion restrictions do not discriminate on the basis of sex because even though they prohibit a form of medical care that only women seek, it is a form of medical care, the court said, that is related to pregnancy, which is a biological fact and is not the equivalent of sex. So based on that reasoning, that abortion restrictions are not, discrimination or restrictions because of or based on sex, this Supreme Court, even if the Equal Rights Amendment were ratified, would say abortion restrictions still constitutional because they just don't discriminate on the basis of sex. That's not to say, don't try to, again, organize around and push for, recognition of the ratification of the Equal Rights Amendment. But it is to say, that is not a one-shot fix. The reality is, there isn't a one-shot fix. Instead, we need to think about how to build institutions that are capable of protecting reproductive freedom and that are responsive to, the people's calls to protect reproductive freedom. Okay. Related to this, the idea that the Supreme Court would not recognize abortion restrictions as a form of sex discrimination. I received a question about, please discuss the possibility of increasing the number of Supreme Court justices. The possibility of Supreme Court expansion is something that I think really gained traction, toward the end of Trump's first term, as Trump, together with the Republican Senate, pushed the confirmation of Amy Barrett through to replace Justice Ginsburg, even though Justice Ginsburg had passed away in September, and they only confirmed Justice Barrett, at the end of October as the presidential election was already underway. And of course, Donald Trump lost that election, in Senate, and the Republicans lost their majority in the Senate. And this was after, 4 years earlier, the Republican Senate had refused to confirm or even hold hearings on Barack Obama's nominee to the Supreme Court, Merrick Garland, who had been appointed to the Supreme Court or nominated to serve on the Supreme Court after Justice Scalia passed in February, when an election was in November. And the Republican Senate said, we refuse to consider or confirm a Supreme Court nominee in the year of an election, only to 4 years later turn around and confirm, someone to the Supreme Court, mere weeks before a presidential election. So the size of the Supreme Court is not something that is established by the Constitution. The Constitution doesn't specify the number of justices. It just says there has to be one Supreme Court. The size of the Supreme Court has changed over time based on laws that Congress has passed. So as a matter of constitutional authority, there's no question that Congress has the authority to change the size of the Supreme Court. It can increase the number of justices as it has done in the past. I think the, concern or possibility of expanding the number of Supreme Court justices is instead a matter of politics, and institutional norms. The objections to changing the number of Supreme Court justices oftentimes sound in the register of, well, if Democrats change the size of the Supreme Court, aren't Republicans going to turn around and just do the same? And then it's a constant escalation. Or, the objection is framed in terms of, well, you can't change the size of the Supreme Court based on objections to the Supreme Court's ruling, because, if you do that, then all of a sudden, Congress has the power to change the content of our constitutional rights. I'm happy to talk more, about those objections, in the Q&A to the extent that's of interest to the people. But there's no question that Congress has the authority to change the number of justices on the Supreme Court. It's just a question of whether they want to exercise that authority, whether the constituents want them to exercise that authority, based on a calculus of, the different benefits and costs and potential costs of doing so. Okay. Another question, please discuss actions possible for citizens to protest court rulings. There are many ways you can protest or lodge objections to Supreme Court rulings. Some of them are formal protests. There were the No Kings protests that were obviously, linked to, this administration. You could organize protests around, the anniversary of Dobbs, or the anniversary of other Supreme Court decisions, that you want to signal, public dissent to. I think it is a reality that the Supreme Court and its justices pay attention to what's in the culture and what's in the zeitgeist. I think the most recent example of this is a phenomenon, that's known as the Kavanaugh stop. And for those of you not familiar with it, I'll explain. So over the summer, a trial court in California concluded that the Immigration and Customs Enforcement officials in California were illegally stopping people based on, their apparent race or ethnicity and the kind of job they had, issued a ruling that prohibited them from doing so and said, that's unconstitutional racial profiling. The administration, as it has often done, rushed up to the Supreme Court and asked the Supreme Court for emergency relief to pause that lower court order such that they were no longer prohibited from stopping people based on their apparent race and ethnicity. The Supreme Court granted them that request. So they paused that lower court order. So they removed the lower court decision that had prohibited the administration from stopping people based on their race and ethnicity, among other reasons. The majority of justices, the Republican appointees, did not explain, why they paused that lower court ruling, but one of them did, Justice Kavanaugh. And he wrote in this separate writing why he thought the trial court was wrong to do so. He said, look, these immigration and customs enforcement stops, they are brief investigative measures, and the officers promptly, let people who are citizens, or with legal status go. Even at the time that he wrote these, it was obvious that these were blatant mischaracterizations and utterly divorced from reality. And so, what happened after? Well, there just continued to be an endless stream of reporting, with videos and photos about what ICE was doing, to citizens, to people with legal status and to people without legal status. These were not brief encounters. People were not promptly let go. Citizens were detained for days. They were being hauled out of cars, shoved on the street, zip tied. Apartments were being raided with Black Hawk helicopters. So people started referring to all of these incidents as Kavanaugh stops. This was written about, in media. This is something that people post about on social media. When I attended the most recent No Kings protest, I carried a sign that said, no Kings, no Kavanaugh stops, and explain what it meant to people. And it's very clear that that got to him. So how do I know that? Because in the Supreme Court's recent case about whether Donald Trump had the authority to federalize and deploy the National Guard in Chicago, Justice Kavanaugh wrote a separate writing, explaining why, he thought the president didn't have authority to federalize and deploy the National Guard in Chicago. That question has nothing to do legally with whether ICE, which is not the National Guard, with whether ICE, can stop and detain people based on their apparent race and ethnicity. Justice Kavanaugh nonetheless went out of his way to write a footnote to his opinion, all of a sudden declaring, that interior to the United States, federal officials cannot stop people based on their apparent race and ethnicity. It was clear he did not want to be associated with, what ICE was doing. The criticism got to him. I don't think that, that sort of protest and criticism is a long-term solution and is going to, fix everything that is wrong with the Supreme Court. But I also think there's no question that, it can matter and that it does matter, and that it's worth engaging in. Okay, so the last question I got in advance, and I see there are already some questions in the chat, is what's the good news? Anything to hope for? I take solace in two things. One is, the massive protests and resistance, that we saw at No Kings protests and that we are seeing every day in Minnesota, my home state. It is very clear that a majority of people, are not okay with what the administration is doing. On a range of different issues, particularly, the abusive law enforcement practices of just like kidnapping people off the street, separating them from their families. Yesterday there was a story about the 5-year-old boy who was, arrested and sent to an ICE facility in Texas. It is very clear that communities, and even people who, self-identify, as Republican and right wing are not okay with what the administration is doing. So I take solace in, those indications of public disagreement and public protest with what is going on. Related to that, I think is the reality that we have seen, I think on several occasions that when people stand up to the administration backs down. The entities and institutions that chose to fight back, to challenge the administration's decision to freeze their funds, to challenge, the administration's decision to revoke their security clearances, to challenge the administration's, to challenge the president's, idea that he was going to all of a sudden seize Greenland. When people stand up and they stand together, that has been able to stop or at least slow down some of what the administration has done. So that is another, source of hope for me. Okay. So now turning to the questions that I see in the chat. Okay. One question. The woman in Texas who died from pregnancy complications and left her 14-year-old son orphan was denied care despite her urgent situation. Can the state be sued or held responsible for negligence that caused 2 deaths? Seems they want to have it both ways. So this is going to get a little into the weeds of constitutional law, but in general, you can't sue a state or the federal government for damages. They have what's called sovereign immunity. They are immune from suit. Now, you can sue, state officers or federal officers and ask a court to prevent them from violating your rights in the future. That is how most of, the litigation against the Trump administration has proceeded. People are seeking a federal court order that prevents ICE from engaging in this racial profiling, from here on out, or that prevents the president from federalizing and deploying the National Guard from here on out. That sort of remedy, however, is not available, and doesn't fix and or address, the problem of people whose constitutional rights were violated or, whose lives were ended in the past. Um, so the doctrine of sovereign immunity, as well as other rules that, limit your ability to sue state and federal officials who violate your constitutional rights, will prevent a lot of people who had their rights violated from actually having a remedy for that violation. This is something that the Supreme Court has really enabled and contributed to. So many people have asked about the possibility of suing ICE officers. We have photographs of particular ICE officers literally holding people on the ground and directly pepper spraying them in their face. When it's clear this isn't done for any sort of like law enforcement or self-defense or crowd control or any other permissible reason. Um, there actually is no statute that authorizes you to sue federal officers who violate your constitutional rights for damages. The Supreme Court, back in the 1970s, the good old days, decided a case in which it said, look, if federal officers violate your constitutional rights and you don't have another remedy, i.e., like it's not going to help you to get them to stop violating your constitutional rights in the future, then you can sue them for damages. That was a case called Bivens. This Supreme Court hates Bivens. Several of the justices have called on the Supreme Court to overrule Bivens, i.e., to say you just can't sue federal officers for damages when they violate your constitutional rights, unless and until Congress says you can. Um, and even the justices who haven't decided to overrule Bivens have said you cannot sue any federal officer for violating your constitutional rights unless you are suing them in a circumstance that is pretty much the exact same as one of the three prior cases that the Supreme Court had decided were circumstances where you could sue federal officers for violating your constitutional rights. None of those circumstances include ICE officers, pepper spraying individuals. And that's why, there just isn't that remedy available in this set of cases. Okay. Next question. Wouldn't it make more sense to put term limits on the Supreme Court justices? I think term limits are a very popular Supreme Court reform. They are one of the reforms that, Joe Biden endorsed, on his way out of office. And they're also quite common, in other constitutional democracies. This is something that, may require a constitutional amendment. There's a difference of views on this question. I happen to believe it wouldn't require a constitutional amendment if you are creating term limits for justices who haven't yet been appointed, that is, who will be appointed in the future. I think Congress could define their term to be a term of years. But I don't think term limits, are the complete solution to the problem that this Supreme Court, is for reproductive rights and justice or for democracy, because you can't apply term limits, to the sitting justices. That means they can decide when they will step down. And we know the Republican appointees are not going to voluntarily step down while a Democrat is in office. And that means, essentially conservative right-wing Republican control of the Supreme Court is locked in for 30 decades. And that means, if you pass the Equal Rights Amendment, it won't make abortion restrictions unconstitutional. That means, if Congress passes a law that attempts to codify protections for Roe, there's no guarantee the Supreme Court won't strike it down. So term limits, are not a fix for a Supreme Court that is hostile to reproductive rights and justice or to democracy, even if they are like a good practice, just institutionally, for how to structure, a Supreme Court. Okay. Please clarify that there is a difference between voluntary abortion and medically necessary abortion. Abortion is an umbrella term for intervention throughout pregnancy. I think there are many different kinds of abortions. There are many different circumstances, that lead individuals to obtain abortions. And I think, some people, will choose to end a pregnancy because they know that under the circumstances, they are not able to or equipped to, have a child, care for a child, or carry a pregnancy to term. Other individuals, may need an abortion because, they face a high-risk pregnancy, or, they experience complications that are life-threatening, or they are carrying, a fetus that is incompatible with life, that may also threaten, their own life. I think one of the things we have seen is pregnancy is just so complicated. It is near prohibitively difficult to legislate. That is, you cannot like write laws that really draw neat categories between different kinds of abortions, some of which you might want to prevent and some of which you might not want to prevent. There are states that have exceptions for cases of rape or incest. There are plenty of states that have exceptions for medical emergencies. And yet in those states, women are still not receiving care, even when they are experiencing life-threatening, health-threatening, fertility-threatening medical complications. Because again, like you can't legislate for all of the possible circumstances that people will encounter during pregnancy and all of the different factual scenarios, that arise, in a matter as complicated as medical care or pregnancy. Okay, next question. Wouldn't originalism analysis cut against creation of fetal personhood? Um, uh, Yes. So, under an originalist analysis, the idea would be, well, did the people who drafted and ratified the Constitution, view fetuses as rights-bearing individuals, such that abortion had to be prohibited everywhere? I don't believe the answer is yes. But that wouldn't necessarily mean that the Supreme Court wouldn't embrace it. Sometimes the Supreme Court is very ostentatious in its embrace of originalism. Other times, less so. Just to give you, two examples. When the Supreme Court in Kennedy versus Bremerton School District said a state couldn't penalize a football coach, who conducted a prayer, on a football field, after a game, they concluded that the Constitution didn't allow a state to penalize the football coach for doing that. They said, well, we decide the meaning of the Establishment Clause based on history. There was not a lick, like not a single reference to any history um, at all. So, like sometimes they will make claims about history, but they're not actually engaging with an analysis of history or historical practice. They are just kind of declaring what they view, the story and values of the country to be. When the Supreme Court dismantled part of the Voting Rights Act in Shelby County versus Holder back in 2013, they declared that the Voting Rights Act was constitutionally suspect because it treated some states differently than others. Um, that is deeply inconsistent with originalism because, of course, when Congress readmitted the former Confederate states, it subjected those states to all kinds of rules, that states that didn't leave the Union weren't subject to. So an originalist analysis would not have led the court to say, it's a problem when Congress treats some states differently than others, but that didn't stop the Supreme Court from saying that. So, the mere fact that a rule is inconsistent with or unsupported by originalism, is not necessarily going to mean, the Supreme Court doesn't embrace it. I think presidential immunity is deeply inconsistent with originalism, and yet all 6 Republican appointees embraced it. Okay, next question. Women are losing pay parity with men in comparable jobs. How can we address this, please? Even women in general exhibit misogyny. How can we also address that as well? Um, you know, I think your question is really getting at 2 different contributing forces, that I think need to be addressed. One solution, of course, is like more legal protections. There are already laws that prohibit uh, employers from paying, women less for doing the same work as men do. The problem is it's very possible to just create different kinds of jobs, and define them with the different responsibilities and then say, well, we're not actually paying women, less for doing the same job. They're doing a different job. And then it just somehow always happens to pan out, that men get the higher paying jobs. How can we address that? I think that is part of the end of my remarks and also part of your question, which is the reality is that like our country has a misogyny problem. And I really think like the only way of addressing some of this is to address that misogyny. How do you do that? I mean, that is a cultural change. That is a societal change. I am not an expert, in how to change, hearts and minds of culture and society, but I think that has to be part of the equation because you can have, the best legal protections in the world, and that is not going to stop people from finding ways around them and people finding ways to, legally do sexism and misogyny, so long as that is like a socially acceptable cultural practice and worldview. Um, Okay. Is there a legal standing is that can be defended to prevent use of traditionalist lens that many SCOTUS justices use today to rule? Ruling based on our country around the 1700s to 1800s makes no sense. Yeah, so, originalism as a constitutional theory is not, uncontroversial. Not all of the justices on the Supreme Court embrace it. Not all of the Republican justices do. Even Justice Alito, the author of the opinion, overruling Roe, ostensibly on the basis of history and tradition and originalism, has openly mocked originalism. In a case, more than a decade ago about whether a state could ban violent video games, Justice Alito mocked Justice Scalia for possibly answering the case based on whether James Madison or what James Madison would think about video games. So, they are well aware of the problems with originalism, and academic commentators and public commentators, have written extensively about the problems with originalism, why originalism is, undemocratic, as your question suggests. So, is there a legal standing? Yes, there are very persuasive, in my view, legal arguments against originalism. I think the success of originalism, has been a product of really like two things. One is just the fact that Republicans have won elections. So they appoint nominees, right, who use a methodology that is susceptible to and compatible with, their political agenda. The second is its simplicity. I think the public is uncomfortable with the idea, that judges who are unelected and unaccountable to the people, make decisions based on their values or their worldview or ideology. And so they want to hear about accounts of judging, that purport to explain why judges aren't, making value judgments or aren't exercising discretion, right, or are really constrained. And originalism is a very like simple slogan, I think deceptively simple in many different respects, that purports to offer like a band-aid or something to cling on to. And I think that simplicity, right, and that kind of deception, is part of also what made originalism successful. When the reality is like life is complicated and nuance is, baked into something as difficult as judging. But nuance and complexity, doesn't sell quite as well as a slogan like originalism. And I think that has been a problem, for progressives with the courts. Okay. Vicky asks, please describe the process of writing your book and what made you decide to do that. So I decided to think about writing a book and basically when the Supreme Court overruled Roe versus Wade. In my view, too many people were just shocked, that the Supreme Court did so and that there was even a possibility that the Supreme Court was going to do so. When in my mind, like it was just perfectly clear when Kavanaugh was confirmed, to replace Kennedy, he was a vote to overrule Roe. And when Barrett was confirmed that the Supreme Court was going to overrule Roe, like the writing was just on the wall. And so I wanted, to give people more background and picture of how the Supreme Court that we have came to be. So people understand like what is driving its decisions and where it is headed. So they understand the scope of the problem, and that puts them in a better position to think about possible solutions and demand different solutions. Getting back to my answer about term limits, I think if, right, you are convinced by what I write in the book about what is driving the justices' decisions and how, the Republican Party has successfully, taken over and captured the Supreme Court, then you would not view term limits, as a sufficient response to, the Supreme Court, such as it is in 2026. Part of what also led me to write the book is, as in the immediate aftermath of the Supreme Court overruling Roe, I got together with one of my best friends from college. At the time we were both not married. We are very hippie lefties who have complicated views about the institution of marriage. And we were having a conversation and she said, I've decided to get married. And I asked her why. And she said, because I don't want, if something happens, I don't want my, father or my brother being able to control like my money or being able to control whether I own property. I would rather that person be my husband. And I'm concerned that the Supreme Court is basically going to allow us to be taken back to a time when women couldn't have credit cards, when women couldn't own property, when women couldn't make financial decisions or enter into business relationships. And I said, okay, like that's like a pretty bleak view of what the Supreme Court might do and where it might be headed. If you think that, like, what do you think about expanding the Supreme Court and changing the size of the Supreme Court? And her response was, oh no, like that's too radical. And my reaction was, well, is that more radical, right, than reverting back to a regime of coverture where women aren't, legal persons with full rights? And so I think like hearing, a well-educated, very successful professional kind of have that response, notwithstanding, her own view about where the Supreme Court might be headed also made me think like, oh, I need to give people more information about how the Supreme Court's like role in our constitutional democracy has changed and how it's not like some fixed thing that has always been the way it is or always has to be the way it is. And so giving more people more information about, different possibilities and how Congress has exercised more control over the Supreme Court, also I wanted to make a part of the book. Um, Describe what you mean by vibes in law decisions. So the full title of the book, as Vicky noted in the intro, is Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. And by vibes, I really mean to draw a pretty pointed contrast to what people think of as law. When people think of law, they think of things that are more like objective and determinate, right? Something that if we all thought about long and hard enough, we'd all arrive at the same answer because there's a correct answer. Vibes are something that's more loosey-goosey. They're more like, well, what are my feelings? Does this upset me? What is the zeitgeist of the cultural milieu in which I am a part of or the political party, that I associate with? And I wanted to, suggest rather pointedly that it's that second category, of vibes, the feelings, the zeitgeist, the political talking points that are doing a lot of work in shaping Supreme Court doctrine and case law today. So that's really what I mean by vibes. And, conservative grievance is, kind of one example of the vibes that I think are driving the Supreme Court today. By conservative grievance, I mean this kind of persecution complex in which they think, religious and social conservatives are, the victims of a society that no longer shares their view. The idea that in the 2024 presidential election, the key issue was this epidemic of male loneliness, not the rollback of women's rights. And so seeing that kind of vibe, in so many different areas of law was something I wanted to get across. Okay, so we are just about at the hour mark. I wanted to thank everyone for attending and thank you for inviting me. I'm sorry if this was a downer, given my expertise. A lot of my talks tend to be that way, but I hope at a minimum it was informative and that you find some reason to stay in the fight going forward.
Leah, thank you so much. It was a wonderful talk, and you can see reactions coming up now. I think you've given us all a lot to think about, and those of us who've been in this fight, who are, 50-year plus members of AAUW, have been at this for a very, very long time, and we're so delighted to have people like you to lead us forward. So thank you, thank you, thank you very much for your talk. This program has been recorded and will be available to everyone who registered for this webinar. And go forth and get back in the streets, ladies. Thank you, and bye-bye, everybody.